Welcome back from lunch. I'm very glad that you all can join us for the afternoon. My name is Ruthie Epstein. I work at Human Rights First in New York. And as you all know, I think we have some new folks in the room, but we have convened a series of 4 events like this one across the country. This is our 4th, and we will be, and we will be holding a final culminating event in Washington, D.C. in February or March of 2013. So we're looking forward to bringing back everything that we have learned here in New Orleans, as well as at the events across the country, back to Washington, D.C., back to policymakers, back to media, and hopefully elevate the voices, elevate the work, and the best practices that have been identified by those of you working on the ground across the country. This panel is titled Conditions of Confinement, What is Civil Detention? I want to start with a quick review of the scale of immigration detention in this country. We did have an overview to open up the morning from Hiroko Kusuda, but for those of you who are new to the room, just want to set the stage. First, when we talk about immigration detention, we are not talking about immigrants in jails or prisons. We're talking about non-citizens held by ICE, held by Immigration and Customs Enforcement, which is the interior enforcement agency of the Department of Homeland Security. Non-citizens held by ICE because they are in deportation proceedings or removal proceedings, meaning that ICE believes they are not in the United States legally. And their cases are moving through the system to determine whether that's in fact the case, or if they have means of relief or a right to remain in the United States under current immigration law. These folks include asylum seekers, legal immigrants who overstay their visas, long-time lawful permanent residents who have been convicted of nonviolent or violent crimes that may make them subject to mandatory detention, as we discussed this morning, and deportation under immigration law, as well as long-time residents who don't have documents and recent border crossers. ICE holds these individuals for a limited purpose, to ensure that they show up for their court hearings and that they comply with any final deportation order. If they have criminal records, they generally have already done their time in the criminal justice system. Legally, ICE detention is not supposed to be punitive. However, in 2011, last year, ICE detained 429,000 individuals in about 250 facilities across the country, including ICE-run facilities, facilities run by private prison companies, and jails. ICE has a total of 33,400 beds across the country. About 1/2 of those beds are in actual jails, this despite the fact that ICE detention is not punitive. The vast majority otherwise are in jail-like facilities. The average length of stay for an ICE detainee is 30 days, but that average is skewed downward by the tens of thousands of individuals who are held just a day or two before they're turned around and deported. The per diem cost of immigration detention to taxpayers, as we heard this morning, is $164 per day per person, at an annual cost to taxpayers of $2 billion per year. There's a reason that we started this day today with a panel on alternatives. Detention should not be the default. We're going to discuss appropriate conditions here, but I want to be clear that our presumption is that individuals should not be detained in the first place without individual assessment, reviewable in court, of the need to detain for reasons of public safety or flight risk, which would require in many cases for Congress to change the immigration law, as discussed by Michael and Anil before lunch, and without a finding that less restrictive alternatives to detention or other forms of lesser supervision cannot mitigate flight risk. Only if those 2 conditions are met should detention even be considered an alternative. Detention should not be the default enforcement tool in either the immigration system or the criminal justice system. Removing a person's liberty, even under, quote, civil authority, is a serious thing. Nevertheless, the commitments of the Department of Homeland Security and ICE 3 years ago to reform the immigration detention system were extremely welcome. The administration recognized that the system looked like a jail system for individuals held under civil authority for a limited purpose. At the time, DHS Secretary Janet Napolitano said, quote, "The paradigm was wrong." And ICE Director John Morton said, quote, "I intend to change the jail-oriented approach of our current detention system, and I'm in the process of redesigning the system so it meets our needs as an agency that detains people for civil, not penal purposes. 3 years later, our purpose today is to talk about what such a system might actually look like. I do want to mention that ICE was invited to join the discussion today. They declined. We hope that they will join us at our final event in Washington, as they're obviously a key player in this conversation. First up today, we have Saul Merlos and Julie Mao of the New Orleans Workers Center for Racial Justice, as well as Jacob Horowitz, who will be translating for Saul and who's also an organizer at the Workers Center. Saul has been actively involved in the Workers Center campaign for the rights of day laborers, and he was just recently picked up in an ICE raid and detained at Bastille for 4 weeks. He was released on alternatives, 3 types, an ankle bracelet, weekly check-ins, and bi-weekly home visits, which seems somewhat overkill to me. He'll help ground our discussion by describing conditions inside Bastille, which has 350 ICE beds and is a 3-hour drive from New Orleans. Julie will talk about detention from her perspective as a staff attorney at the Workers Center. Next, we'll hear from Katie Schwartzmann, managing attorney of the Louisiana office of the Southern Poverty Law Center. As many of you know, she's been a driving force behind a federal lawsuit against the Orleans Parish Sheriff, charging that his indifference created brutal and inhumane conditions at the Orleans Parish Prison. The federal complaint describes violence, drugs, physical and sexual assault, denial of mental care for prisoners with mental illness, and overcrowding. She brings the particular perspective of an attorney who's fighting the most egregious conditions in America's prisons. And given that, I'll be interested to hear her thoughts on baseline humane conditions of confinement, as well as the concept of, quote, civil detention, which seems so very far away from the reality lived by thousands of pretrial inmates at OPP. And finally, we're lucky to have Will Harrell, criminal and juvenile justice reform consultant and director of Justice Collaborative LLC based here in New Orleans. I've asked him to talk not only about conditions of confinement, but also about mechanisms for oversight and accountability, which are so essential. A blueprint for appropriate conditions of confinement means nothing without the mechanisms in place to make sure that its intent is fully realized, that detained individuals actually do live in safe and humane environments that respect their dignity. Julie and Saul.
Thanks, Ruthie, for the introduction. So, hi, everyone. My name is Julie Mao. I'm a staff attorney at the New Orleans Workers Center, where we support community leaders and civil rights community members who are fighting to demand fundamental change, just migration, and dignity at work. Today, we have the great opportunity of hearing from a voice in the front lines of this fight. Saul Merlos is a member of a civil rights membership-based organization in New Orleans called the Congress of Day Laborers. He is also a member of the Sun 32, which is a group of civil rights leaders who are facing deportation because of egregious civil rights abuses here in the Deep South. But Saul will talk about his experience.
Muy buenas tardes, mi nombre es Saúl Merlos, soy miembro del Congreso.
Good afternoon, my name is Saul Merlos. I'm a member of the Congress of Day Laborers.
Quiero contarles un poco de mi experiencia. Yo tengo 18 años acá en Estados Unidos y tengo una hija de 13.
I've been in the United States for more than 18 years and I have a 13-year-old daughter.
El año pasado en una redada en Kenia, fui testigo del trato que se le dieron a unas personas en un apartamento que incluyéndome a mí, yo estaba ahí.
Last year I experienced and was witness to an immigration raid in my apartment in Kenner, Louisiana, where I saw very bad conditions take place.
A un amigo lo agarraron, lo golpearon, lo tiraron al piso y a su esposa y otros muchachos que estaban arriba los bajaron y la señora llorando con su niña y le hablaba muy fuerte.
One of my friends was beaten by the ICE agents there. He was grabbed, he was thrown to the floor and cuffed. The ICE agents yelled and screamed also at his wife, who was carrying a small child and was pregnant.
yo estaba en el sofá durmiendo, entonces me dijeron que me tirara al piso, me amarraron, me apretaron muy fuerte las manos, que 2 dedos se me durmieron de mi mano derecha.
I was asleep on the couch at that time. I was also grabbed and arrested, and they cuffed me so tightly that my fingers went numb.
Y bueno, esa vez tuve suerte, salí de que me soltaron, y este año nuevamente, hace aproximadamente 5 semanas, me volvieron a arrestar en un parqueo.
So I was lucky enough to be I was released that time, but then this year I was also assaulted by ICE in a parking lot.
Luego me llevaron al centro de detención en Basilia, y el trato que nos daban era demasiado malo.
I was taken to the Detention Center and experienced horrible treatment there.
La comida era muy poca, y algunos de mis compañeros, como era muy poca la comida y a veces daban 2 piezas de pan, trataban de querérsela llevar para más tarde.
They don't give you sufficient food in that detention center, and so many of my friends who are detained there would try and take a little extra bread and bring it back to their cell.
Porque era muy difícil lo poco que nos daban de comida, y ellos se la quitaban y la tiraban a la basura.
But the guards would take that food from them and throw it away.
Luego, aparte de eso, habíamos algunas personas, habían unos que padecían de diabetes.
Also, some of the other detainees who were sick and had diabetes.
A veces los tenían, alguien que nos checó de que si estábamos enfermos o no, hacían lo que ellos querían, nos permitían que se checara su sangre.
You know, even though the doctors had given them permission that they should be able to check their blood sugars before eating, the security guards wouldn't allow them to do that.
Uno de los muchachos, compañeros ahí, la comida le cayó muy mal un día y le dio como alergia, se puso muy enfermo, la piel se le puso muy roja e inflamada y se rascaba hasta la cabeza porque se sentía muy mal, parecía morirse.
One of my friends there had an extreme allergic reaction to something in the jail, something he ate, and his whole body became inflamed. He was scratching himself all over. He thought he might die because he couldn't breathe well.
Entonces todos nosotros le tocábamos la puerta, golpeábamos las mesas, lo que pudiéramos golpear para llamar la atención, porque se le había tocado una ventana y no querían atenderlo.
He had tried to get the attention of the guards, but they wouldn't attend to him. All of us we had to start banging on the tables and on the floors in order to try and get their attention so that they would help him.
Luego llegó alguien de los de seguridad y dijo que no era nada, que más tarde tal vez lo llevaban a algo de medicina.
When a guard finally did come, they said, "Oh, he's fine, maybe later we'll bring you some medicine."
Sí, más tarde, como a la hora, lo llevaron a darle algo, una pastilla, no sé, y porque él estaba demasiado enfermo.
It took them over an hour to come to bring him something or to attend to him because he was so sick.
Entonces, yo quiero decirles que gracias al Congreso yo salí de ese centro de detención y luego me pusieron un grillete.
So, thanks to the Congress of Day Laborers, I was able to get out of detention. But coming out, I was, they put an ankle bracelet on me.
Y yo pienso que eso es injusto porque yo he tratado de recuperar mis papeles desde el 2006.
And I don't think that's just. I'm a person that's been in process. I've been getting my papers since 2006.
Y he estado yendo a las cortes puntualmente cuando me las habían dejado, y ahora mismo pues andar con un grillete, pues yo me siento como persona muy mal.
And I always have showed up for my court dates and immigration appointments, and having this bracelet, it makes you feel really bad.
Y por eso estoy acá, para que algunas personas que escuchen, porque tal vez cuando estamos ahí adentro, habemos muchos que decimos, ya tenemos mucho aquí, porque hay unos de 6, 7 semanas. A veces sí nos dan ganas que nos saquen y nos tiren para nuestros países.
And now that I'm out, I'm here to speak up and to expose the conditions there. Many people, after you've been in the jail for 6 weeks, 7 weeks, many people decide they just want to sign their deportation orders and leave.
Entonces, pues el hecho de venir yo acá es para que algunos escuchen, porque yo lo viví en carne propia, lo que es estar en esos centros de detenciones.
But I'm not doing that. I'm coming and I want to speak to you and tell you, because I lived in my own flesh and blood what it's like to be in one of these detention centers.
Y sé que esto va a ayudar a otras generaciones, otras familias, en este caso he sido yo, y si esto pues llegan a hacer cambios, quiero ser parte de eso, de que se hagan logros.
And so I'm speaking because I want to make changes for other generations and other people so that they don't go through the same thing. I want to be part of this movement to make these changes.
Pues una vez más gracias por venir y por escucharme o escuchar las cosas que tenemos nosotros los que hemos sido agarrados.
So thank you so much for coming to listen to the conditions of we who have been detained.
So with the remaining time that I have, I'd just like to briefly bring up some of the work experiences that we've had at the Worker Center, as well as talk about how that relates to greater detention policy that we're seeing on the ground here in New Orleans, as well as the greater South. The experience of Saul is not isolated. Many of our community members in New Orleans are facing very, very similar situations as Saul. One group that I wanted to briefly talk about is the Southern 32, which Saul is a part of. The Southern 32 is a group of grassroots labor, human rights, and civil rights defenders who are facing deportation as we speak because of either three things. They stood up to exploitative employers. Two, they stood up to a sheriff and a police force in New Orleans who are abusing their powers, or they have stood up to DHS agents, either ICE or Border Patrol, who have acted outside the law. It's workers on day labor corners. It's Saul and a group of day laborers who are now standing up against a very violent ICE raid that happened last year while workers, these day laborers, were in the midst of a labor dispute and had gone to an apartment complex to receive their pay and were met by 40 to 50 ICE agents. It's an individual named Harrell Diaz, who could not be here today, who was picked up in a warrantless home raid of his house and brought to Basile Detention Center in 2009, where he led a hunger strike of about 60 detainees to protest inhumane conditions there. And also asked for national oversight of those conditions. Many of those striking detainees were retaliated by the prison guards, placed into solitary confinement, in order to prevent them from reporting inhumane conditions to government officials as well as civil rights advocates. The New Orleans Worker Center was able to reach those detainees and support them in their hunger strike, create safety plans so that they could finally report their experiences in detention to government officials and ask for national oversight. And it ended up being that the director of policy reform at DHS at the time, Dora Shiriro, came into the Basile detention facility to meet with hunger striking detainees to talk about basic protections and conditions in detention. It's individuals like Delmi Palencia, who just a couple of weeks ago testified before the DOJ civil rights hearing on the NOPD consent decree, who was racially profiled by NOPD, arrested and placed into Orleans Prison Parish, and had to fight and file a habeas petition in order to challenge the unconstitutional practices of the sheriff on ICE detainers. So I guess the question is, how does that sort of all relate to detention policy in Louisiana and the Greater South? Well, the truth of the matter is, none of the individuals in this group of 732 should be in removal proceedings, let alone in detention, based on the written current policies of ICE on prosecutorial discretion. As some of you may know, in 2011, Director John Morton issued a memo called the Certain Witnesses, Victims and Plaintiffs Memo, in which the document explicitly states, quote, "It is against ICE policy to remove individuals in the midst of a legitimate effort to protect their civil rights and civil liberties," and that the purpose of this policy is to, quote, "avoid deterring individuals from pursuing actions to protect their civil rights." What we're seeing on the ground is that that policy is not being implemented, and that people, the individuals who are in detention right now are individuals who are fighting for their civil rights. They are the faces of the 732, and all three of the individuals that I just mentioned specifically had to face detention before we could come in there and get them out. I think it shows us that we have an egregious detention policy here in the Deep South with too many beds, right, and poor detention conditions, excuse me, that is driven by an aggressive enforcement policy that runs even contrary to the stated policy of the same agency. It also problematizes exactly who it is that we are putting in detention. We are filling our beds with people who are community members, who are mothers, who are civil rights activists, who are trying to fight for a better day for our community. I think Saul's experience that he's just said has also shown that the current detention system that we have is certainly punitive in nature, and there is no significant difference between the criminal detention system and its emotional and physical effects on people and the immigration detention system that we have. I think finally I just want to say that we are deeply appreciative and deeply supportive of the criminal justice advocacy community that we have in New Orleans. I think that going forward, in terms of immigration advocates, we have to really be collaborating and working with criminal justice advocates. The work that the juvenile justice community has done in detention centers like Jenna, which was actually a juvenile facility that was closed down because of really strategic efforts and detainees who exposed the egregious conditions there, but now has reopened up as an immigration detention facility housing more than 1,000 detainees. So I'll leave it at that. Thank you.
Hi everybody, I'm Katie Schwartzmann. I'm the managing attorney for the Southern Poverty Law Center's Louisiana office. And I have to say at the outset that I know very little about immigration detention. My background is in Louisiana's criminal justice system, working in the prisons and jails throughout the state. My one experience in an immigration detention facility was actually a couple years back when the Workers Center let me tag along on a visit. Really struck in that visit by the fact that it's a prison. It looks like a prison, it smells like a prison, the administration treats it like a prison, and the desperation in the client's eyes that are in there is the same that I see in my clients who are in the criminal justice system, who are behind bars in that system. Only maybe worse, because you have language barriers, and you have a huge geographic distance oftentimes between the detainees and their family members, so it's almost more isolating. So I just want to issue the disclaimer at the outset that I don't know much about conditions of confinement in those detention centers, but I think I was asked to talk today because the legal framework that we use when we talk about conditions of confinement in the criminal justice system has sort of translated and morphed into the immigration conversation. And so it's useful for us as advocates in thinking about what detention makes sense and what we think that should look like to understand the criminal justice paradigm, I think, legally. And so if you think about the big overarching goal of our criminal justice, or our prison system, I guess, it would be to deter crime and to punish crime. And some people might argue that it's also to rehabilitate, although I would say that after spending a lot of time in these jails and prisons, there's pretty much no opportunity for personal growth or expansion. That the system is really designed to punish and to warehouse people as they do their time. And the legal framework that sort of informs the standards that govern kind of how the conditions are there is the 8th Amendment to the United States Constitution, which says cruel and unusual punishment can't be imposed as punishment for a crime. If you break the law, we can't punish you with something that the courts determine is cruel and unusual. The courts have struggled historically to figure out what is cruel and unusual punishment. It means theoretically that you can't have force used against you without a good purpose. It means that if prison officials know you have a basic human need that's being denied, they have an obligation to fulfill it. Those human needs are defined at, unfortunately, very low level. You got a right to a roof over your head, clothes, food, not that much else. In some circuits, you have a right to a bed. So the standards are really low. And then you have a right to medical care, and that is defined as treatment for serious medical needs. And that's for people who are convicted of crimes. That's what the 8th Amendment kind of sets as the threshold. Now, in the criminal justice context also, we have people who are detained in our jails and prisons right alongside people who are convicted of crimes who are pretrial. They've not been convicted of anything. And the Constitution affords them with a higher level of protection. It says, we can't subject these people to any punishment because they've not been convicted of anything. So what we have to do is hold them and maintain them until they can go to trial. But constitutionally, we're not allowed to punish them. This is interesting, and to me, when I was thinking about today, it like perfectly parallels actually with the immigration context and this idea of civil detention. Because what does that really mean if we can only detain somebody to ensure that they show up for court, but we're not allowed to punish them? How do we go about that? And so I kind of started poking into what courts have said about, what does that mean? What rights do pretrial detainees really have? And I gotta tell you, the courts are as confused as we are about what a humane civil detention system would look like. How do you hold somebody without having an amount of punishment? And a lot of the circuits have kind of thrown up their hands and said, we don't know. All we know is they sure can't be punished worse than those 8th Amendment prisoners that are already convicted. So let's just apply that as the standard. And I got to confess, I've done that in my briefs. When we filed our suit against Orleans Parish Prison, we had pretrial guys and we had convicted guys, and I was like, I'm just going to use the 8th Amendment standard because we're sure violating that, and so I don't need to argue about whether there's some higher standard of care. But for the purposes of this conversation, I think it's really important that, I think it's an opportunity for us to start talking about what civil detention standards could look like and what that really does mean to try to house people without it being punitive, and really question, I would, whether that's even possible philosophically. I looked at the recent ICE changes that Julie mentioned in the detention standards and the recent ABA standards that came out that make some pretty significant progress as to what immigration detainees are entitled to. There's some great stuff in there about contact visits with your families and the ability to move about the facility, email access, law libraries. And I don't want to say that, those are really important gains, and I don't want to say anything that insinuates that it's not, because my clients who are in the criminal justice system lose their minds when they don't have access to their families and access to the outside. Those are things that people need to really survive. So they're important gains. But the larger issue, I think, is that with the fact of detention come necessary human rights violations that arguably amount to punishment. The deprivation of liberty but also, as was mentioned a second ago, the fact that you're at the whim of guards and prison officials who oftentimes are prone to abuse and abusive practices. So I guess I'll just close with saying that the courts in the criminal justice context haven't done a great job of defining how we can house people and detain them and have it not amount to punishment. And that's the same standard that our courts are applying to immigration detainees now. And so the conversation maybe that we really need to be having is what Ruthie alluded to, which is it better to talk about alternatives to detention, and isn't that really wouldn't that really be the constitutional standard now that we're in 2012 and there are alternatives to detention that maybe didn't exist previously, such as intense supervision, that sort of thing. So I think it's an opportunity for a conversation shift, probably both in the criminal justice system as well as in the immigration detention context.
First, I'm Will Harrell. I want to first start by thanking Human Rights First for engaging this conversation. I am generally an optimist, but I am not terribly optimistic about the topic that's in front of us today. But one day we will turn the corner. The conversation we're having today is a conversation that began probably 15 years ago, intensified a decade ago, in the criminal justice realm. Criminal justice reformers picked up some momentum about a decade ago and are having some real impact. But it didn't start off like that, and we have a long way to go. I heard Michelle Alexander speak the other night, and if you ever have a chance to hear her, Professor Alexander speak about her awakening and her book recently published about the new Jim Crow, which speaks and critiques mass incarceration. I encourage you to hear it, but I was thinking in the context of this, and this perhaps isn't, is better described as the new Jaime Crow, because, we have built these prisons on a binge, and criminal justice reform is happening. I participated in reforms in Texas where, thousands and thousands of less people are incarcerated each year, but the institutions are built, and they are there to remain. And it has become a very lucrative option, particularly for private vendors, to incarcerate and make money on the backs of poor immigrants, including those fleeing persecutions in their homes of origins. It costs about $10 to $12 a day to operate, per prisoner, to operate a detention center, be it a criminal incarcerated person or a person being detained for immigration violations. The state of Louisiana throws out a per diem of about $20 a day, so there's a small profit margin. But the ICE pays anywhere from $50 to $100 a day. So it's a potential, a lucrative operation. And GEO and the American Correctional Association are all over this and seeking government bids all the time. Katie mentioned earlier about the emptying and movements of facilities. I once, as an ombudsman, was observing the conditions of confinement for juveniles in a little prison in West Texas, in a town called Bront, and found it to be the most horrid conditions I'd seen in any U.S. facility. Within a week of the report, 197 kids were removed from that facility. The facility didn't put up much of a fight. It was operated by GEO, because for a couple of years they had figured out we need to shift into the immigration detention business because it's more lucrative. The per diem that they were getting to manage a difficult population, being juvenile delinquents, was much lower than what ICE would pay them to manage a much more manageable, easily manageable population, being low-risk immigrants, for the most part, low-risk immigrants. So good luck to you, Ruthie. Much respect for you taking this battle on. I know it's rough to be the canary in the coal mine, but you'll get there. We'll make progress, and this is a great beginning. I didn't come here to talk about that. I came to talk about the importance of standards and the importance of normalizing an incarceration environment and the importance of independent external oversight in these detentions. And I'll start by, you've heard from Saul about his experience in detention here in Louisiana. And a broader statement was, I'd like to read from, is most detention, from your law review article, Professor, most detention facilities, the report notes, were designed to hold criminal suspects, offenders, non-immigration detainees, and most detention officials have experience in law enforcement, not civil detention, and alternatives to detention. Even the government's detention standards, which advocates initially welcome, inappropriately draw criminal incarceration policies, practice designs for criminal pretrial detainees, and are overly restricted to immigrant detainees. You've heard a lot about that today. There have been 4 standards produced that detention facilities are supposed to follow, but they're based on the adult correctional model, which are to be applied to a very different population. But the reality is these standards aren't truly enforceable. I mean, meaning they're not binding. There is a existent current system of monitoring, but it is why there's an important distinction. But currently, ICE deploys a contract facility monitor who's recently lost their contract. I understand that there might be a new one already. But these are a for-profit company that's making money to report to ICE what I think ICE generally wants to hear, and not necessarily a harsh critique. I understand there's some genuine and good people in this business and doing this work, but they're not inclined to report in a manner that an independent monitor is likely to do. This is particularly troubling considering the fact that the immigrant detainee population is growing, and they're scattered all around the country in far-flung rural facilities that contain distinct populations themselves. Some facilities may house 10 to 20 people, whereas some facilities like in Houston, Texas can house upwards of 2,000 people. Standards, the population in which these people are mixing with, are very different in different places. That is why there's a necessity for meaningful, obligatory, and binding national standards that address the needs of these individuals, not this different individual. And it's got to be enforceable by a centralized authority, because the standards, the actual practice and policy in these facilities all over the country and all over this state can be vastly different. There's a certain type of expertise that would be necessary to adequately monitor these facilities. There's a handout in the back if everybody was able to pass by and pick it up. It's a resolution that was produced by the American Bar Association, I think a year or 2 ago. I'm not going to go in great detail through the principles that are outlined in this policy, and there's some great research published in the last year's PACE University Law Review by a woman who I think is the leading voice on independent oversight, Professor Michelle Deitch. But this law review article and the principles by the American Bar Association, which is not necessarily a radical organization that is noted for bombastic approaches to human rights, has recognized after many years the need for independence. And I'm not going to go through all the details, but I recommend this article. But I want to talk to you from personal experience why this is important. I mentioned earlier the Bront Juvenile facility that I observed. I was the independent monitor for the state of Texas evaluating conditions of confinement in juvenile facilities. I went to the facility and I discovered an overcrowded institution that was hyper-violent, that staff really weren't tending to the needs or the violence of the youth, and it was a very dangerous, scary place for juveniles. I wrote a report that had to be submitted to the Senate because of the way that the statute in the office was set up. A senator leaked it to the press, and because of the expose of the conditions and the way that it played in the media, the facility was shut down. But there, for years, had been 4 internal monitors actually located at that facility. And those monitors had ranked the facility, according to their review, at like a 95% compliance rate on what the conditions of confinement were supposed to be. Now you wonder, how could they have done this? I'm personally pretty convinced that one of the people was on the take for GEO, and that person is now enjoying comfortable contracts with GEO corporations. But there were 2 others who I think really cared about kids, but didn't know any different, that they had only been exposed to the conditions of incarceration for these kids at this institution, so that was their norm. So what they reported out was, something that appeared to them to be just fine. Having an external person who had no contact or benefit from maintaining the secrecy of the conditions of that position helped expose the conditions, but also having somebody trained and external come in helped to acknowledge and realize the problems associated with the conditions that those kids were living in. And I've left Texas. I don't know what had become of that facility, but my understanding is it's now an ICE detention facility, and I seriously doubt that those conditions have changed. We wonder why this is important. I think most people who came to this conference today because you have some empathy for the immigrant community. I'm quite sure of that. But let's go away from that. Why is it important to have decent conditions of confinement? Well, for one thing, all of these people are going to get out one day. They might be integrating back into our communities or back to communities where they came from, but either way, they will be released. If you don't adequately attend to the health care while these people are there, then you're going to have a bigger problem on the back end. Another reason that's not about the empathy for the immigrants is think about the staff. The staff suffer the same conditions that the immigrants or criminally accused people suffer in these facilities. To the extent that these facilities are decrepit, hot, the treatment is adequate, they're violent, that affects staff too, and they bring that home into our communities. And that's why there's a high level of family violence amongst people who work in these facilities. Another reason for people to be concerned about this is the fact that U.S. citizens travel abroad, and what's good for the goose is good for the gander. Do unto others as you'll have them do unto you. The minute U.S. tourists get treated the way that immigrants in this country get treated will be the day that that country is going to be forced with some political retaliation from this country. So we might as well think through that and the way that we treat people who are here in our own environments. Steve Martin is quoted in one of the reports from this organization as saying, quote, "The extent that you can normalize the confinement setting is the extent to which you have a safe environment." Steve Martin is one of the monitors that the Homeland Security Department's Division of Civil Rights and Civil Liberties goes in and does facility evaluations. He works with me on juvenile detention reform in the state of Ohio. He's the former general counsel of the Texas Department of Criminal Justice. He was a prison guard at the age of 17 until he was in his early 20s, was a parole officer as he went through law school. This is a law and order kind of guy, but he, through his own experiences, realized that if you don't treat individuals, humans, as humans while they're incarcerated, or rather you treat them like beasts or animals, they're going to behave that way. And it's particularly true in the juvenile context, but it's always the case. The programming proposals by Human Rights First and others are not unreasonable. The right to visit, Katie mentioned the mental impact and deterioration that we can document of incarcerated people who've been denied access to their families is very real. The inability of people to get up and get outside and to exercise is very real. And you contain people under highly restricted conditions, they're going to react sooner or later, and that usually manifests in violence on detained people, or violence on staff, or mental health or physical health ailments. So it is in our own best interest to raise the standards and make standards binding and observe them and elevate the humanity of these conditions as long as they're here. But let me just say, in my experience in criminal justice reform, the best fix to conditions of confinement is shutting down the front gate. The reality is, every problem that's associated with the detention of people is exacerbated by the more people you have there. So to improve conditions of confinement for detained people will require alternatives to detention, and it will require, quite frankly, in this country, comprehensive immigration reform that doesn't involve increased mandatory detentions and options of that nature. We've got to rethink this. We can't afford to keep acting this way, and it's not humane to keep acting this way. So with that, I want to thank you again, Ruthie, and good luck to you, sister.
It's my first pound on a public panel. Thank you all. That was great, and I have a bunch of questions for all of you. Is this mic on? Thank you all. That was fantastic. I appreciate the perspectives of everyone on this panel. And I do have a bunch of questions. I'd like to start with Saul to reground us in the personal experience. Saul, could you tell us if you were to change anything about your experience at Basile, aside from the fact that you were there, what would it be? What would you recommend to the people running that facility that they change?
Bueno, una de ellas sería, pues, se puede decir acerca de la comida, porque es demasiado poca, como quiera nosotros, los hispanos, a veces estamos acostumbrados a comer normal.
Well, one of the things that I would definitely change is about the food, because they don't give you enough food there. We're used to eating more than they give you there.
Y el aseo también, el personal.
And also the cleanliness of the place.
Y acerca también del trato, acerca cuando alguien está enfermo.
And also in terms of the treatment for people who are sick.
Okay, thank you very much. That it? Okay. Kind of building on that, I'm interested to hear from Will, as you mentioned, the value of normalized conditions to improve safety in a facility for detainees as well as for staff and officers who go home to their families having worked and experienced home and into their own communities. Can you enumerate what normalized conditions would look like from your perspective as someone who has inspected many facilities of confinement?
Professor Quigley, Religious Council, will remind me, what is it, the idle mind is the devil's playground. And it's particularly true with juveniles, and a lot of immigrant detainees are young. But if people who are detained don't have activity, the mind runs afoul, and people get frustrated and angry, and if their energy that's pent up isn't allowed to flow, then that will ultimately come out in different ways. And so recreation and programming activity are fundamental. People have to be kept busy. But then there's fundamental issues like, mental health needs. I mean, somebody was mentioning earlier about particularly some people coming to this country seeking asylum who've suffered trauma in one way or another, and that's exacerbated in these environments. And that has to be tended to. There's medical care issues, if left untreated, can develop into something worse than it was in the first place. But visitation is critically important. Contact visitation particularly, but also telephonic communication is important to keep people together. And the minute they will unravel, that creates problems for them, not only them, but for other detained persons as well as the staff.
Okay, so if I may, those all sound like perfectly reasonable conditions to expect in a correctional setting as well, which brings me to the issue that I've been struggling with for some time, working on this issue, and interested to hear from both Will and Katie again. Does this mean anything, this concept of civil detention? Are civil, and you know, I'm playing devil's advocate to my own work because this is what I do, but should these conditions that we're saying are baseline conditions appropriate for civil confinement facilities really be considered baseline conditions appropriate for any facility of confinement?
I mean, I think absolutely. And, you know, earlier maybe I was like too dismissive of how important these conditions are, but what Will said is absolutely right. In the criminal justice context, the facilities that we see that spiral out of control, like we've seen at Orleans Parish Prison, where it is just a violent facility. People are stabbing each other, raping each other, hitting each other. And, you know, these cases come into my office and I step back and I'm like, my God, what is going on? Like, how is this happening? How are people doing this to one another? Like, what's going on in there? It all comes from the culture that's set by the deputies, the leaders of the facility, and what, as Will said, is afforded to people as basic human dignity and treatment in there. And if you have a facility where, again, people are denied rec and they're denied books and access to their families and stuff, it spirals out of control really quickly. And again, the same thing when I went to the Bazille facility. I think it looks like a prison, it's treated like a prison, and the same standards really, I think that we're talking about applying in the immigration context through these new ICE regs and ABA standards and talking about what's humane and what's civil, absolutely needs to be talked about in the criminal justice context. And if we don't start talking about it in our context, the facility is going to continue this like downward spiral that they're on.
I think those are just basic needs that should be attended to while incarcerated, but I mean, as a lot of people have said before, even that is modest. I mean, there should be, and I agree with the panel before, any independent assessment of the risk that each individual presents, and making a legitimate decision of whether they should be detained at all, and I don't think so. There's nothing good that will ever come from detention. I mean, we're talking about people who may be there for a month or two, but some that'll be there for 6 months, a year, or more. So that this has an impact, and and a cost associated with it. But another thing is that there's a classification instrument that's used in ICE. That's sort of a one-size-fit-all, and it so you've got some non-violent, low-risk people housed with potentially violent people. You've got some medium-risk people mixed with high-risk people. You're mixing a non-violent population with a population of potentially criminally violent people when you mix them in these jails, which is, I think, a much larger problem, much more serious problem, grave problem, is the situation that immigration detainees are facing in these prisons and parish jails that we don't know much about. There are people who are incarcerated who will victimize other people. That's just the fact and the reality. And those who are weaker and less violent are the ones most likely to be victimized. So we're seriously putting people at risk by ignoring the reality that they might face when they enter these walls.
Thanks, and I just have one more question for you all, and then we'll open it up to the audience to ask any questions that you may have. Back to oversight mechanisms. So ICE has no external oversight mechanisms. The Office of Civil Rights and Civil Liberties under DHS does have the authority to investigate complaints that are brought before it. but that is not the same as a sort of day-to-day oversight process, and that is, though it's not part of ICE, it is part of the Department of Homeland Security, which is also the agency under which ICE resides. So I'm wondering if you can sort of imagine what an independent oversight entity for ICE might look like in the federal government? Please.
I mean, there's a lot of potential models. I mean, in Canada, there's an ombudsman for the whole state that has different divisions that can evaluate, investigate, monitor any type of institution, mental health, criminal jails, immigration facilities. I mean, there's a lot of models. I mean, Department of Justice could do it. Could handle it with. Because there's not, as we've discussed, the standards aren't hugely different. But one thing that's important, and I spoke with Steve Martin last night, a man who I have great respect for, who I monitor Ohio juvenile facilities with, who is one of the Civil Rights, Civil Liberties Department investigators, and he's like, you know what it takes. In Ohio, we've been involved and engaged with a system that was profoundly unconstitutional 6 years ago, who within the next year or two, I think, will be the exemplary model juvenile system in this country. One visit a year with a report on a checklist would not have gotten it there. What it's taken is a coaching relationship. We've been engaged daily, rewriting policies and procedures and training staff on that, developing buy-in, and helping a shift in the culture and the attitudes. It's an ongoing, sustained relationship. A drive-by, old school checklist audit does not change anything. And the way that it works is Steve can go and break it down better than anybody I've ever seen in this business. But he leads, and it's up to the individuals at that facility to make the changes or not. It's an internal operation. There are people in agencies who are under monitorship who like the fact that they're under monitoring because they want to do the right thing by these kids or by adults. But they are not getting the funding and the resources that they need to do it. Having an external, independent person calling you out for the problems that aren't your choice. These are not problems by choice, but they're problems due to lack of resources or other priorities. It will help the institution if there's a centrally developed, respected, independent, ongoing monitor relationship out of some government agency that isn't ICE, that is not the jailer. It's, quis custodis codore, a Latin term that's been around for hundreds of years. We've always wondered, who will watch the watchman? It's a fundamental question. Lawyers don't police lawyers real well. Doctors don't police doctors real well. Why would we expect jailers to police themselves really well?
Thanks. I'm going to open it up to the audience as well as the panelists. You may have comments or questions for each other. So.
I have a couple of questions, if I may. The first is whether any of you have noticed differences in, or perhaps Will specifically, ability to access facilities and sort of examine the conditions between private and public facilities, whether the privatized facilities are more opaque. I don't know whether they are. And then the second question I had is based on what Saul was saying about, that's the first thing that came to mind is something that could be improved is food. And as people, I'm guessing may know, food is something where the law is very unfriendly. The law basically says as long as it's nutritionally adequate, it can be the most disgusting thing in the world, and it passes muster. And I'm curious whether that could be a dimension along which there is a divergence between criminal and civil detention, and if anyone has any thoughts on pathways of sort of organizing around better food. I know it sounds a little frivolous, but I just think that it was, really soul crushing to be fed disgusting stuff. So.
I'll start with that. First, about access to privates versus government-run facilities. There should be no difference because privates are operating on a government contract, which is another reason why standards are so important. Binding standards that are meaningful in this context, because those are the standards. GEO contracts with ICE to do it. ICE has a contract monitor who says you're out of line and non-compliant with these standards. You've got the basis to withhold money from the contract or remove the contract. So that's an incentive to ICE to perform. But that depends on how intent the monitor actually is. The goal is profit. And a profit, for-profit, prison, or whatever operation. So if I know it's going to cost, the bare minimum is $12 a day, and I'm going to get $50 to $100 a day to do it, I'm happy with that profit. But if I can cut it back to 10, that's even better on a daily with private run facilities. The issue about food, there's nothing trivial about that at all. And you're right, and this again goes to normalization, the importance of normalization. The correctional model is how many calories are you going to give them a day, and that's the end of the analysis. It's not about the humanity of enjoyment. It's not about flavor and taste and touchy-feely notions like that. It's straight calorie count. And I can tell you, due to lack of food or lack of good food in detention facilities, that's one of the leading causes of youth-on-youth exploitation and violence. I hate what they served me at lunch today, so I'm going to steal your snack when we get back to the dorm. And then that creates violence, gangs, and gangs trade food. It's a real failure to properly think about food. Nothing trivial about it at all. I'm glad you raised that.
I just want to add what might sound like a small point to what Will said, but it's important for us in Louisiana. We actually have had a hard time holding the private immigration detention facilities accountable under the state public records law. I don't know if y'all are familiar with our state statute, but it allows you as a citizen to get government documents or any sort of information that's generated by the government by state statute. And the private facilities in Louisiana have taken the position that they're not subject to the state public records law. There's a bad Supreme Court case, unfortunately, that agrees with them. So that's one way in which the continued privatization of these entities also does sort of remove them from our ability as citizens to exercise our oversight over them.
Yeah, and I would just say quickly that just as a comment about food, I think for our members who participated in this hunger strike, part of a significant reason why they engaged in such courageous efforts and faced the consequences and risks of retaliation was because of how the food was making them sick at Brazil. And so it's not just like what Will was saying, whiny people saying that they're not getting Whole Foods bread as opposed to regular flour bread. It really is a part of a dehumanizing process where people really feel at a fundamental dignity level that their rights are being violated. And I think just on some comments that were made before about how do we get supervision in these detention centers, I think one way in order to get that is to think about how do we support directly affected people, like detainees, in coming forward and making complaints. Because currently the system is pretty bad. People who engaged in hunger strikes and tried to report the health and safety conditions of Brazil were placed into solitary confinement. And so we have to be questioning ourselves, what is the solution to that? Is it some more independent monitor of DHS? Since the watchers right now are the ones who are the watchmen.
Yeah, let me just add to that. That's right. Katie's right. And I was coming from I've been an official monitor, either working for the executive branch of government or the federal judiciary. But that's one of the key components. If you look at these ABA standards of independent monitoring to make it effective, or any monitor, is golden key access. Full access to any facility at any time of day or night, any room and corner of that facility, all records, and to be able to confidentially have interviews and conversations with not only detainees, but staff who work there. And most of my best information comes from staff who would probably be fired if it was known that they told me what they did. So that's sort of whistleblower protection, confidentiality of interviews, and complete unfettered access are key to effective oversight.
And I can respond to the question of access in regards to ICE facilities that I've experienced as a researcher going out and taking tours of immigration detention facilities. Under the Obama administration, NGOs have experienced increased access to ICE detention facilities in terms of taking tours of the facilities. There's a process that's now in place, much due to the work of one of our colleague organizations, the Women's Refugee Commission, that makes it much easier for an NGO to make a formal request to ICE to tour a facility, and then that request is processed through standardized channels in order to get to the folks who actually run the facility. And I have actually not heard of a single NGO that's been denied such a tour under those circumstances. It's certainly not golden key access. It's not like we can show up, on a random day, random time and say, can we please take a tour? But it is better, I want to give them props for opening up the doors more than had existed under the prior administration.
Sue. Yeah, since we're talking about normalization of civil detention, I thought this might be a good point to talk about ICE's efforts to build civil detention centers, but the way that those efforts have been defeated by immigrant advocates in those communities. And particularly southern Florida and the Chicago area. One of the biggest problems with the ICE detention centers is not only the miserable conditions, but how they're so far, they're far removed from, major population centers. So ICE says, okay, we're going to build civil detention centers, we're going to build them near large population centers, and then they're just beaten back, totally, it won't, it's not allowed to happen. Immigrant advocates beat it back because they don't want to see an expansion in the detention system. I get that, neither do I, but I understand that if that's not used, then we're going to use these hellholes in Nowheresville, Louisiana. And the same thing happened up in, Chicago. So it just seems as though we're cutting off our nose despite our face, but worse, we're cutting off the noses of the immigrants that have to go into detention despite our faces. I'm not getting that. It seems like ICE believes they must fill 34,000 or whatever detention beds. So if they can't fill them at these nice civil detention centers with basketball courts and dorms and, movie theaters or whatever, they're going to fill them again in these horrible places. So I just wanted to know if how you all are seeing that issue, because it doesn't seem like there may be a disconnect there. Tell me how you see that, Ruthie.
Yeah, I have a lot to say about that, so I don't want to talk for too long, because I could talk for an hour about, you've very clearly articulated a central tension in the reform efforts of ICE and among advocates for reform who are approaching the issue with different strategies, with different priorities, and also responding to different stakeholders and from different levels in the system. So it's tough. That's the short answer. I do think, ICE has made these attempts to open more facilities with more appropriate conditions for the immigrants that it holds in its custody. And a couple problems with those attempts. Well, one big concern, I think, for a lot of reform advocates is that ICE is looking at partnering with private prison companies to open these facilities, because those are the entities that come forth and say, yeah, well, give us your RFP, we'll do what you want.
But who else will build it?
But who else will do it? So that's one sort of conundrum that has no easy resolution. And then a very real fear of if you build it, they will come. And we have not seen a commitment from the agency to close an inappropriate facility before or alongside opening a more appropriate facility. And so I think the advocates on the ground who are leading these site fights understandably fear that an opening of a new, quote, more appropriate facility will just lead to an expansion of beds across the system. And I think, history of prison building in the United States does not undercut that understanding or that expectation.
Well, I would say that actually ICE has reduced the number of facilities that they're using now, right? It used to be 350 really horrible places like OPP. Now it's down to 250. It's still almost the same number of beds. So, anyway,
May I just say, I think it's an interesting concern. I think it is really problematic that the policy stance of ICE is that it is potentially that we need to deport X amount of people and we need to detain X amount of people, right? The original frame is that if people are not significant security concerns, they should not be in detention in the first place. So what is this quota of how many people need to be in detention? And I think we can see that sort of same dialogue and dialectic come out of very good work that OPPRC and many of the criminal justice advocates are convening around Sheriff Gussman's request to build a bigger jail that's going to be nicer. There'll be a couple, double or probably more the amount of beds, but it'll be nicer, right? And how that would really fundamentally change, the conditions, maybe they'll be better, but at the same time, I think that it is a huge concern if they build it, they will come. I think also...
But I would also say there's an unlimited number of hellhole jails that will take detainees, okay? So I wouldn't agree with that argument that if this isn't built, they'll put a certain number in these hellholes, and the pressure point should be at the appropriations point in the process when they're determining how many detention beds I fill in the year. And there was a lot of pressure put on this past year, and at least the beds didn't go up, and they didn't go up. They remained the same, and they did increase ATDs. So the OPPRC thing, totally get that. You build a bigger jail, this city will fill it. But I'm saying that there is already an infinite number of crummy jails in this country to detain immigrants. And if you build civil detention centers, then people that are detained, at least they're detained in more humane situations. Let me get that straight. But that's not the reality. Okay, people will be detained. So are we going to allow them to be detained in more decent, more humane places, closer to counsel, more than anything? That's probably the most important aspect of it. They can get a lawyer and get out. Versus let's just regardless, just fight it, and we'll just let people go off.
I think it's definitely true that the advocacy has to come. The fight has to happen on all fronts, right? Whether it be fighting to get counsel into detention centers, making sure that counsel is regularly able to get to detention centers, whether it be lessening detention as a whole, our discussions about alternatives to detention. I think also a discussion of why is there enforcement to begin with on this population and community, right? So I think that that you addressed a very good point, and that, you know, it speaks to the fact that we have to be there at all angles of the fight.
Okay, with that note about access to legal counsel, I think I want to wrap this panel discussion up. It's been fantastic to hear from everyone here, and you know, we all have, this conversation could go on, and it needs to continue going on, so I appreciate the engagement of everyone in the room. We'll take a 5-minute break, and then come back for the final panel of the day.